Hello AP students, I'm here to talk to you about the judiciary, the subject of Article 3 in the Constitution, a very short article. In fact, that article only identifies one court to be created, that is the Supreme Court, but then says that Congress shall create other courts as they might want, okay, which is how we get all of what the Constitution calls inferior courts. Okay, so to start out with, the judiciary's importance is crucial. They are the branch that has taken on the role of deciding what the law is and applying that law. That's the doctrine of judicial review, of course. They have a couple of different ways of helping ensure their independence. One is life tenure, the fact that they're given life tenure. Remember that Federalist 78 talks about how important that is with the judiciary, given that they're a very weak branch in the first place. Okay? And then the other thing they have, which actually Hamilton mentions in Federalist 78, but which Chief Justice Marshall declares in Marbury v. Madison, the doctrine of judicial review, which establishes that they can decide whether something that another branch does violates the Constitution. All right? We've been following that system. We've been doing it. We'll see if the current administration is willing to follow court orders past what they have so far. There are, the power of judicial review basically checks the other parts of the federal government very much. One of the things we always say when we talk about what checks the Congress or what checks the presidency is their power of judicial review and their ability to declare some act of Congress or the executive as unconstitutional. Okay? The court is also tasked with the job of making sure that states follow the Constitution, because the Supreme Court is the court of last resort for states when it comes to federal constitutional law, right? They're the court of last resort for lower courts in the federal court for opinions of all kind. Okay. Now, what are the sources of federal judicial power? Okay. Number one, as I mentioned, Article 3. Number 2, as I also mentioned, Federalist 78. And number 3, as I mentioned, Marbury v. Madison, which establishes the doctrine of judicial review. Those are documents that might show up on an FRQ, for example, as the basis for whatever opinion you're going to express. Now remember that not everybody agreed then, or even agrees now, that life tenure is a good thing for judges. Okay? I read something recently about a guy that proposes a term, I think he said 14 years, and he had a reason for that. But not everybody agrees with life tenure, and one of the reasons is because it does give significant power to the judiciary. Okay? Brutus was one of the people that talked about that, so when you go back over Brutus, you'll want to look at that. Now, one of the things that the Supreme Court does, or that the courts in our country do, is they follow the common law, which is a British system. Okay? Under the common law, laws developed through the actual decision of cases in actual factual circumstances. Okay? And in doing that, what you're supposed to do as a court is to follow the decision of a prior decision that's authoritative over you. You're supposed to follow that. Okay? That's called the principle of stare decisis. Stare, S-T-A-R-E, decisis, D-E-C-I-S-I-S. Okay? And that's what basically controls the direction in which the law goes. Now, every court is supposed to follow previous precedent, but we all know that sometimes the Supreme Court doesn't, that they change their minds, and they're basically the only ones entitled to do that under the system. Okay? Now, how does the Supreme Court decide whether to overrule a decision? How does it decide to follow a new path? Basically, it depends a lot on the ideological balance of the court, or lack thereof. It depends on which presidents have appointed them, and how they turned out to be as judges. What kinds of things do they think are important legally? What kinds of legal principles do they follow? For example, are they fans of the view that business should be promoted above all costs, or are they fans of the view that we need to protect civil rights at all costs? Okay? But that changes depending upon who nominates the judges and who is in Congress, who's in the Senate, in order to confirm them. Now, what are the checks on judicial power? Okay? First of all, Congress can pass legislation to modify something that's the subject of a prior Supreme Court decision. Okay, if they're able to modify it and make it constitutional, they can do that. Second, the Congress can start the process of trying to pass a constitutional amendment that will change the principle of the Constitution that the Supreme Court applied in a case. Third, and this is the slowest method, is to change the people who are on the bench, the judicial appointments and confirmations angle, all right? As far as I know, there's only been one instance where we've been able to do that really in this country, and that was during the New Deal when Franklin Roosevelt was fighting the Supreme Court tooth and nail, but eventually, took a few years, but eventually got a court that would go with him. And that was due to people dying or resigning, so that Roosevelt got new appointments. Now, the next check on judicial power is that sometimes the president or the states, whoever the ruling applies to, try to ignore the Supreme Court, as the southern states did when the court ruled in Brown versus Board of Education that school segregation had to stop. Right? I was trying to think of another example. And you all know of the example of President Jackson ignoring the Supreme Court's decision about the land belonging to the Creeks, I believe it was the tribe. Okay? Now, another thing that we haven't talked very much about, but I'll mention, that is a check on the judiciary, is that Congress can pass legislation and the president can sign legislation that changes the court's jurisdiction. They can't change what's in the Constitution, but most of the rules about what kinds of cases a court can handle and when they can handle them and where they can handle them are created by Congress. So if the Congress doesn't like something that a court's doing, say a specialty court, they could theoretically simply abolish the court, or they could change what it is that the court is allowed to do. Finally, judges can be impeached. That doesn't happen very often, but it has happened. Okay? Now let's move on to some kind of legal requirements that you must have in order to get into court at all in the United States system. Okay? And this is anywhere in federal courts. There are 3 basic requirements that we want to talk about here. One is the case or controversy requirement. The case or controversy requirement comes from the Constitution. And it says that you must have an actual dispute, not a hypothetical dispute. You can't go to a court and say, if, for example, we did thus and so, what would you say? What would you rule? We can't do that in our system, okay? You need an actual dispute, an actual problem that's going on between 2 people or 2 parties or numerous parties that the court needs to address. Second, there's the need for a person filing a lawsuit to have standing to sue. Standing. Okay? What that means, what that requires is that the plaintiff, the person filing the lawsuit, have suffered some real substantial injury, or it must be such injury must be immediately threatened. Okay? That it's coming down the pike and you know it. That's standing to sue. And then finally, there's the justiciability requirement. This is actually addressed in in Baker versus Shaw, I believe it was. I don't think it was Shaw versus Reno, where the court addressed something that the defendants were claiming, the gerrymandering issue is what they were talking about, and the defendants were claiming that this was a political question, not an appropriate question for judges to decide. Okay, judges are there to decide legal questions, something that can be based on the law, not politics and opinions about who should govern the country. Okay, and so if you don't have that kind of question, the court's going to dismiss your case, going to get rid of it. All right. Okay, now let's talk about court structure for a second. As you know, there are basically we talked about a lot of different kinds of courts, including specialty courts, but the 3 main levels of courts that you need to know are, starting at the top, the Supreme Court. Okay? Again, specifically listed in the Constitution. Okay? The Supreme Court is the court of last resort for everything, pretty much. Okay? They do not take all cases. We'll talk about what they do take in just a minute. The second level is the Circuit Courts of Appeal. There are 12 of them, okay? And they are courts of appellate jurisdiction. The Supreme Court, as you know, has both original and appellate jurisdiction. All right? It can take cases as a matter in their initial stage. That's original jurisdiction. The kinds of cases that the Supreme Court has initial jurisdiction over are cases involving ambassadors or other persons' diplomatic staff, and cases mostly involving states, okay? Though not states, not suits by citizens against their own states. That's in the 11th Amendment that you can't do. They had people do that at the beginning of the country, and they decided to change that. Okay? So, that's the Supreme Court jurisdiction, and the appellate courts, the courts of appeal, of course, have appellate jurisdiction, which means they can hear cases on review for error. They look at what was done at the trial level of a court, and they decide whether there's an error, a factual error, or a legal error. It's a lot easier to make your case if you have a legal error, because we respect juries' decisions on factual matters. Okay? And then the lowest level of court is the district court. That's the trial level court. They have original jurisdiction. They don't do much appellate work. They sometimes review decisions of agencies, but you don't really need to worry about that, okay? If you want to file a case in federal court, what you do is you get yourself a lawyer and you put together your paperwork and you go to a district court and you file your paperwork, okay? And then that district court is going to handle your case from there through trial, all right? Okay. The kinds of cases that are heard in federal courts as opposed to state courts obviously are cases that involve the U.S. Constitution or cases that involve U.S. federal law, okay? They involve cases that are diversity jurisdiction where you have people from different states who are the parties in the case, and that allows you in some instances to go into federal court, okay? You have some legal matters are going to be heard only in federal courts, like patents and copyrights and bankruptcies, for example. Admiralty law, which has to do with the seas, okay? State courts handle mostly state court matters, all right? If you think that something that a state court does is a violation of the U.S. Constitution, then you can go into federal court. You can appeal to the Supreme Court. It's the it's the last stop, even for state cases, not just for federal cases. Okay. So, how do judges become judges? Okay. Basically, you need to attract the attention of the president because the president is the one who's going to nominate you. Why would the president nominate you? First of all, you share the president's ideology. Okay. If they're conservative, you're conservative, and vice versa. Okay. You want to be someone who is known as a leading legal figure. It could be that you've been a judge in a lower court, lower federal court, or even a state court. It could be that you've been involved in government. You were the attorney general or something like that. Okay. Could be that you were a professor at a law school, or maybe you were a lawyer. Okay. But you need to be somebody that should be respected as an attorney. Now, presidents sometimes nominate people who really aren't respected as attorneys, and usually those people don't go through. They usually don't get confirmed. Okay? So the president chooses someone. The president is supposed to get essentially the approval of the senators, at least one senator, preferably both senators, in the state where the nominee is from. Okay? If those senators are from the president's party. Now, a lot of times senators think you should do that regardless of party, but this is called senatorial courtesy. Okay, as a courtesy, the president goes to the senator and says, this is who I want to nominate. You got a problem with that? All right? Also, when we talk about judicial nominations, we talk sometimes about litmus tests, and these are basically bright line issues that will make a difference for whether the president or the Congress will confirm you, okay? So a lot of times they're political. We talked about how the most important litmus test recently has been abortion. How do you feel about abortion? You're either red or you're blue, okay? One or the other. And that's why we call it a litmus test. And they have had different litmus tests over time, okay? I imagine that during the Cold War, they talked a lot about communism in the hearings, the judicial nomination hearings. Now, to be confirmed, what does Congress think, the Senate think about when it decides whether or not to confirm a judge? Well, obviously they think about ideology as ideology too, but there's some sense, and at least there has been in the Senate, that if the person is a good lawyer, even if you don't agree with their politics, you should confirm them. That has been under attack a little bit lately, and some people might accuse the Senate of being more political about their judicial confirmations. But and sometimes the decision has been political, but I think the reason for the political decision, for example, in the case of Robert Bork, was that the American people did not want this. This was not consistent with the American people's interests. Okay. Let's talk about approaches to judging, okay, and to the Constitution. So first of all, if you're a judge, someone might call you someone who's a judicial activist. What does that mean? Actually, let's go back for a second and let's go back to the Constitution. How do judges interpret the Constitution? Okay, there is one train of thought, one branch of thought that says that is called originalism, that says that you should interpret the Constitution either as the framers originally meant it, or as the people that heard the Constitution in the beginning would have understood it. Okay, how would they have understood it? What would they have understood it to mean at their time? An ordinary person. Okay, so both of those are branches of originalism, but they both basically say you take a look at the Constitution and what the way people were when the Constitution was framed, and that's how you look at it. Okay, obviously that would put us in a different place as a country if people actually followed that or had followed that all the time, right? Now, another approach to interpreting the law, interpreting the Constitution, has to do with how you construe the terms, okay? So there's one approach called strict constructionism, which basically you think the Constitution says exactly what it says and you don't infer anything from it, okay? You don't try to figure out you don't try to read between the lines, okay? A loose constructionist says that you're supposed to understand the document as a living soul. The Constitution is a living document, and it can live and breathe with the changing times. And a loose constructionist said you should let that happen. Okay? For example, as with Obergefell, the case that said that people couldn't ban gay marriage, that states couldn't ban gay marriage. Okay? The Constitution was living and breathing, expanding with the times in that decision. If you are a judge who is more willing to find a decision, to find a congressional action or a presidential action unconstitutional, we tend to call you a judicial activist. Or the other reason we might consider you a judicial activist is if you think we should consider matters that are traditionally outside the judge's views, matters about what's going on in society. Okay, for example, when the court decided that the death penalty was cruel and unusual for juveniles at the time of the crime, they said that if you looked around the world at other countries like us, that nobody has the death penalty. Okay? That this is passé, that this is not, now, a lot of, the judges who disagreed with that vociferously. Okay? But that's one way to think about judicial activism. Judicial restraint is obviously not being willing to go out on a limb like that. Okay? Now, basically, I think we have one more topic. Is that right? Yeah. Basically, we need to talk about how you get on the docket. Okay? So, unless you have original jurisdiction, you have to convince the Supreme Court, to take your case. They only take about 100 a year, less, maybe even less now, okay? But they get like 9,000 requests, okay? So what do you do to try to get the Supreme Court to take your case? First of all, you want to have a particular kind of issue in your case. You're going to be much more much more successful in getting them to take your case if you have a very, very important national legal issue, something like gay marriage. Okay? Another reason is one of the Supreme Court's important purposes, aside from being a court of last resort, is to keep the federal law throughout the country uniform. We obviously have different district courts in 90-some different places. We have appellate courts in a bunch of different places, a dozen different places. And they're all interpreting the law in there as they understand it, but obviously they're not always going to agree. So the Supreme Court exists to iron out those wrinkles and make sure that the law is consistent. Okay? So one of the ways to get on the docket is if you have one of those cases that has created an inconsistency in the courts of appeal decisions. All right? Now, so you prepare your papers. What do we call those papers that you submit to the court and say, here, I've got this important case you should take? We call that a petition, okay? It is a petition for what? A writ, which is a court order, of certiorari, cert, okay? You are asking the court to take your case and put it on the docket. Now, what happens at the Supreme Court when they get your petition? Well, they look at your petition. The law clerks look at it, and the judges consider it, and they decide whether or not they want to take the case. They have a vote among the justices. How many do you have to have in order to get the case on the docket? You have to have 4. That's called the rule of 4. Okay? If 4 justices agree to put your case on the docket, then you get on. Now, sometimes they put you on the docket and then they kick you off later on. They call it improvidently granted, but basically that's how you get on the docket. And then you have briefing, and the court has a hearing where you show up and talk, and the court issues a decision. The decision that has the most judges is called the majority decision, the majority opinion, okay? And they don't always agree on everything. Sometimes you have scattered opinions. But basically what you're hoping for is an agreement by at least a majority of the judges on the court, which would be 5, okay, as to what they want to do about a case. Now, the judges who disagree with the majority opinion might file a dissenting opinion to explain their reasons for their dissent, their disagreement, okay? And in all these opinions, majority and dissenting, other judges can join. So the majority opinion, you assume that all of the judges in the majority join that opinion. For the dissenting opinion, sometimes they do separate dissenting opinions, and sometimes they do them together. And sometimes they each do separate ones and join each other's. It's kind of crazy, okay? There are other opinions that I'll just mention. One is called concurring. If you're a judge who agrees with the result, but you don't necessarily agree with the reasoning, or you want to add something to your explanation, you can file a concurring opinion. Okay? I believe that pretty much gets us to where I wanted to go. So that's the judiciary. I'll talk to you later when we get to the next subject, political culture.